So the accused before me is charged of hate speech. This is contrary to section 13(1), subsection A, and then the subsection 2 of the National Operation and Integration Act of 2. This was on the 7th of September 2020. And 42 is some of the same counts. And 3 is that he uttered used abusive words on social media, which were likely to cause breach of peace. Now, 5 witnesses have been called by the prosecution as at the close of their case. I will not read the analysis. I have made an extra copy for the perusal. I will not read the evidence. I will just read my finding and determination as to whether the prosecution has made out a case to warrant this accused person to be placed on its defense. Submissions by both parties have been considered. They are fairly detailed, and I have considered all the submissions, and right away I'll go to my determination. I have considered the submission by the parties and the case recited. The starting point will be to look at the applicable law and the cases on prima facie case. I will then evaluate the prosecution evidence with legal principles to make a finding on a prima facie case. I have looked at section 306, subsection 1 of the Criminal Procedure Code. Of course, the definition in the Oxford Companion of Law at 3907, which has given a definition of what a prima facie case is: a case which is sufficient to all an answer, while prima facie evidence which is sufficient to establish a fact in which the absence of any evidence to the contrary is not conclusive. And case law in this is a Malaysian court. This is Public Prosecutor versus Anwar bin Ibrahim, number 3 of 1999. As also defined, a prima facie case arises when the evidence in favor of a party is sufficiently strong for the opposing party to be called on to answer. The evidence adduced must be such that it can be overthrown only by rebutting evidence. It must be such that if rebutted, it is sufficient to induce the court to believe in the existence of the facts stated in the charge, or consider its existence so probable that a prudent man ought to act upon the supposition that those facts existed or did happen. And this exercise cannot be postponed to the end of the trial. a maximum evaluation of the credibility of the witnesses must be done at the close of the case of the prosecution before the court can rule that a prima facie case has been made out in order to call for the defense. In criminal trials, the burden of proof is always on the prosecution. A trial court is therefore enjoined by law to determine whether at the conclusion of the prosecution case there exists a case discharging that burden of proof. In discussing the issue further, the case of the Sanjit Jatai and versus the state. This is reported in 1985, 39 WLR 925, and the ruling is that submission that there is no case to answer may properly be made and upheld when A, there has been no evidence adduced by the prosecution to prove the essential elements of the alleged offense. Then number B, when the evidence adduced by the prosecution has been so discredited that no reasonable tribunal could safely convict on it. So that is so much so for the issue of the case to answer. Now, the accused is charged of the offense of hate speech, and I have taken the liberty to read section 13(1), subsection A of the NCIC Act. And of course, I have relied on the Act itself, the preamble. It is that it is an act of Parliament to encourage national cohesion and integration by outlawing discrimination on ethnic grounds, to provide for establishment, powers and functions of the National Cohesion and Integration Commission, and for connected purposes. Now, the prosecution witnesses number 2 and 3, the evidence was limited to conducting the operation at the accused home, and at the close of the operation, the evidence is that the accused was not at home, so the evidence likely was on the raid towards establishing that the accused, on the instruction that the accused had committed the present offense, and this accused person later presented himself to the police station. Prosecution witness number 1 said that in his evidence, the accused had made certain utterances, and the clip was picked, and the same had certain issues that were contrary to the NCIC Act. The sentiments attracted backlash from the public, who dismissed the utterances as reckless and likely to cause potential harm. The witness prepared a report and presented the same in evidence. However, on cross-examination, the witness said that the clips was about harassment of allegedly the deputy president. There was no report on the authenticity of some of the accounts. He could not tell where some of the commentators lived. He was also not aware if there was a complaint that was made against the accused informant. There were other clips that showed politicians who had made certain utterances, and the same were under investigation. The witness in his evidence said he did not, or he was not the one to determine the agents with which these particular cases were taken to court. Prosecution number 4, in his evidence, told court that some of the utterances made by the accused person were actually factually correct. That for one, it was true that Kenya belonged to 50 million Kenyans and not the Kenyatta family, and that women had breasts, and the mere mention of Kikuyu and Kalenjin was not in itself hate speech. And then finally, there was an issue that which was also factually corrected, that Kinjuri and Songo, as at the time of the alleged utterances, there was Kinjuri and Songo who had Kinjuri had been sacked and Songo had been impeached. The witness further said that there were no tribal clashes that were witnessed due to the said utterances. There were more likes than dislikes to the clip. There were other utterances that were made by other civilians and politicians, and have not been, no action had been taken. I will address this issue later in my ruling on the issue of inaction or action on the part of the NCIC. Now, the prosecution witness number 5, in his evidence, stated that the accused, the utterances made by the accused he processed the plea and presented the same evidence. On cross-examination, the witness said that there were more, according to his report, there were more likes than dislikes, and the channel that he picked this clip from was not registered in Kenya, and his evidence was that it is actually normal on social media platform for people to make comments, likes and dislikes. And according to him, the National Police was the complainant. If the likes were more, that did not mean that the comment was not hateful. There was admission on the issue that the present accused before me was processed with the utmost speed. I will not really comment on the issue, considering that the National Cohesion and Integration Commission is established under an Act of Parliament, and it can only be left to do its work, so I cannot make a determination as whether there was maybe malice on the part of the NCIC to process this accused person with speed as submitted by the defense. And of course, the DPP has the final word on the mandate to charge accused person. So I will leave it at that, and I have relied on 2 cases. Of course, you will appreciate that the National Assembly Speaker, the Speaker of the National Assembly versus Jenga Karume, and of course the Gladys Boschole versus the Judicial Service Commission. The holding is that where there is a procedure for redress of any particular grievance prescribed by Constitution or an Act of Parliament, in this case the NCIC Act, that procedure, or they say sticks to the body, should be able to do their job. So I will leave it at that. Now the question then that follows next is whether the prosecution has made out a case to warrant the accused person to be placed on his defense. The evidence, as already analyzed, shows that the utterances were made at an unknown place, and I looked at the plea, which was actually also played in court, and I could also not tell you whether this was at a public place or not, because a close look at the clip that was played, I did not see any members of the public present. The prosecution have not, in their evidence, presented any evidence to show that due to the said hateful message at the clip, it started creating hatred within the area where this accused person comes from. Of course, it is common knowledge that he's a member of parliament of Kapseret, and this Kapseret is a cosmopolitan area, or anywhere within the Republic of Kenya. So the prosecution, witness number 4, saying that there were demonstrations in relation to count 2, but when it was examined on this issue, there was no evidence that was presented to prove that there was such demonstration. Some of the accounts that were used to comment on the clip that was, or that is the subject of the charges before me, had not been verified. There was no verification report that was filed by the prosecution. Some accounts, particularly there is one account that was created shortly after the clip was aired. The question then that arose is whether some of the accounts were created for purposes of reacting to this clip. It is a question that is left to be answered by the prosecution, considering that the accounts were not verified. The other issue is that there were no members of the public, or in this case, an opinion leader from the communities allegedly mentioned in the clip that were called by the prosecution to adduce evidence to the effect that the words that were uttered by the accused who is before me stirred up ethnic hatred. The prosecution witnesses told me that a mere mention of the word Kikuyu or Kalenjin were not really hate speech. Now, the Constitution 2010 guarantees the right to freedom of expression, but the same as limitation, and does not extend to propaganda for war, incitement to violence, hate speech, or advocacy of hatred that constitutes ethnic incitement, vilification of others, or incitement to cause harm, or is based on any ground of discrimination specified or contemplated under Article 24 of the Constitution. The NCIC Act criminalizes hate speech and provides for a penalty payable in the event one is found guilty. I have looked at or relied on the case of Chirawali Makwere versus Robert M. MBELE and 2 others. This is reported electronically in 2012. Hate speech, incitement to violence, and other forms of expression are excluded from the ambit of protection of Article 33, subsection 2 are not defined by the Constitution because of the deleterious effects of propaganda for war, incitement to violence, hate speech, and advocacy for hatred, which I have referred to. That is the only, not really me, but that is the only which I have referred to in Article 33. Sanctions are imposed on such conduct through criminal law. Section 13 and 62 of the NCI Act give effect to state objective to promote ethnic harmony and national cohesion by prohibiting hate speech. This objective is consistent with the national values and principles of the Constitution, particularly human dignity, equity, social injustice, inclusiveness, equality, human rights, non-discrimination, and protection of the marginalized. Further, that coming back to our legislation, reading and applying the plain meaning interpretation of Section 13, I do not find that the provisions simply criminalize the voicing of historical injustices as contended by the petition in Section 13. Section 13 only curtails such freedom of a person who intends to stir up ethnic hatred or having regard to all circumstances, ethnic hatred is likely to be stirred. It is thus not merely a question about falsity, felicity, truth, popularity, or otherwise of a particular information or expression. It could appear that the statute lays more emphasis on the likely effect of the objection of information and the intention of the person delivering it rather than the content of the objective. So the last bit in this Nakuru case, that the statute places more emphasis on the likely effect, so the starring effect on ethnic hatred. Now, it is no doubt that the accused person before me is a politician, and the sentiments expressed by him may have been as a result of political frustrations on his political side. If you look at the case of Kanini Kega versus Okoa Kenya movement and 6 others reported in February 2014, the holding is that a political question does not lend itself to splitting by the court of law. From the evidence, in light to count 1 and 2 then, the evidence that has been presented so far, it is obvious to me that the facts as pleaded do not fit the definition of hate speech as set out in the said law, and I so find. There is a second issue on the offensive conduct on the part of this accused person. What the prosecution needs to establish is that the accused was at a public place. 2, he used the abusive words as against the complainant. 3, he acted with the intent to provoke a breach of peace. I have also taken the liberty to look at the definition of a public place as provided in the Penal Code, and of course the interpretation and the General Provisions Act, which defines a public place which includes every place to which the public are entitled or permitted to have access, whether on payment or otherwise. That is from the interpretation of the General Provisions Act. Now, the prosecution evidence is that the offensive words were uttered at an unknown place, and they say they were likely to occasion breach of peace. Having considered the evidence of all the witnesses, there is no witness who has stated that the effect the words uttered had on them, the effect the words uttered had on them. In the matter where it is alleged that the act was intended to provoke breach of peace, that the prosecution duty is duty bound to prove beyond reasonable doubt that the act complained of was likely to make people resort to physical violence. This is a position that has been fortified in the case of MBELE versus Republic. This is criminal appeal number 873 of 1982. In the absence of evidence that any of the persons mentioned or that a member of the public said that the words uttered by this accused person were abusive, and evidence as to how they reacted to the said words, the prosecution witness said that there were demonstrations at Kiambu, but there was no evidence that was presented that there was really any evidence, or sorry, any demonstration in relation to the words that were uttered by the accused before me. There is no indication that the said words having, there is no indication of the said words having caused provocation, and therefore, thereafter, caused breach of peace. The upshot is that really the prosecution has not presented sufficient evidence to warrant placement of the accused person on count 3 on his defense. Now, the court then, as it lied, there is a case of active party versus Republic. It is a 1957 case of the East African Law Courts 332 to 335, where the court held that, remembering that the legal onus is always on the prosecution to prove its case beyond reasonable doubt, we cannot agree that prima facie case is made out if, at the close of the prosecution case, the case is merely one which, on full consideration, might possibly be thought sufficient to sustain a conviction. This is perilously near suggesting that the court will fill the gaps in the prosecution case. Nor can we agree that the question whether there is a case to answer depends only whether there is some evidence, irrespective of its credibility or weight, sufficient to put the accused on his defense. A mere scintilla of evidence can never be enough, nor can any amount of worthless, discredited evidence. It may not be easy to define what is meant by prima facie case, but at least it must mean one on which a reasonable tribunal, properly directing its mind to the law and the evidence, will convict if no evidence is offered to the defense. Now, the result of all that is that I have found in favor of the defense, and my finding is that the accused person has no case to answer, and is therefore acquitted under Section 210(6). So that is my ruling.
You are much obliged, Your Honor.
Yes.
We will be praying if you may that you supply us. Sorry, Your Honor.
1 second. Yes.
On behalf of the defense, Your Honor, we wish to very amply request that we be supplied a copy of the ruling. Your Honor, the defense is also grateful that the case, though blistering, we were given an opportunity to be heard, and the court, despite the pressure of work, has been able to hear this matter and render a ruling within 1 year. We wish you a good weekend.
If we could make an order, not automatic, that the past friends of he released the deposit.
Your Honor, we also pray for a copy of the ruling.
Okay then, copies of the ruling to be supplied to both the defense and prosecution, and the cash bail that was deposited to be then released to the depositor. Okay then, have a good weekend ahead. The defense, you are copy here, and prosecution you can.
Yes, 293/2018. Michael Kipsang with Kirwa. ENC number 293, the people file.
What is the intention if you can maintain silence? Yes?
Mimi kuna kelele mingi.